Welcome to another episode of the Divorce Lawyers podcast, brought to you by DivorceLawyers.ca, your trusted source for family and divorce law in Ontario, Canada. I'm Deepa Taylor, and today we're diving into a topic that many couples consider before tying the knot, but might not fully understand the implications of prenuptial agreements. Specifically, we'll be discussing the potential pitfalls of these agreements and what you need to know before signing on the dotted line. Prenuptial agreements, or prenups as they're commonly known, are legal contracts that a couple signs before getting married, outlining the division of assets and financial responsibilities in the event of a divorce. While prenups can provide clarity and protection, they also come with potential risks and challenges that can lead to significant legal battles if not properly drafted or understood. Today, we'll break down these pitfalls and offer some advice on how to navigate them. First, let's start with the basics. A prenuptial agreement is designed to protect assets that one or both partners bring into a marriage. Common reasons for getting a prenup include protecting family wealth, safeguarding a business, or simply ensuring that both parties are clear on their financial rights and responsibilities. However, it's crucial to understand that a prenup can't cover everything. For example, in Ontario, the right to occupy the matrimonial home cannot be waived in a prenup, regardless of who owns the property. Let's break down what a prenup can and cannot do. It can dictate how assets and debts will be divided, how spousal support might be handled, and even address some issues related to estate planning. But what it cannot do is override certain statutory rights, particularly those related to child support or custody, which are determined based on the best interests of the child, regardless of any agreement between the parents. Additionally, it's important to note that a prenup must be fair and reasonable at the time of both signing and enforcement. If a court finds that the agreement is unconscionable or was signed under duress, it may be overturned. We'll discuss these issues more in depth later in the episode. Now that we've covered the basics, let's talk about some of the common pitfalls associated with prenuptial agreements. One of the biggest issues we see is the last-minute prenup. This happens when a couple waits until the 11th hour before the wedding to draft and sign a prenup. Not only does this create unnecessary stress, but it can also lead to one party feeling pressured or coerced into signing. In legal terms, this could be considered duress, which might render the agreement invalid. Another common pitfall is inadequate disclosure of assets. Both parties must fully disclose their financial situations, including all assets, liabilities, income, and expected inheritances. If it's later discovered that one party wasn't fully transparent, the court could invalidate the entire agreement. It's also essential to ensure that both parties have independent legal representation. While it might seem easier or less expensive to use the same lawyer, this can create a conflict of interest and result in the agreement being challenged later on. Finally, one pitfall that's often overlooked is the need for updates. Life circumstances change. People acquire new assets, start businesses, or even move to different jurisdictions. A prenup that made sense at the time of marriage might no longer be relevant or fair years down the line. Regularly reviewing and updating your prenup can help avoid future disputes. To give you a better understanding of how these pitfalls play out in real life, let's look at some case studies. These examples are based on real cases in Ontario, though we've anonymized them for confidentiality. First case study, the last-minute agreement. In this case, a couple decided to sign a prenup just days before their wedding. The bride felt immense pressure from her in-laws to sign, even though she wasn't comfortable with some of the terms. Years later, during their divorce, she successfully challenged the prenup in court, arguing that she was under duress and didn't fully understand the agreement. Second case study, the hidden assets. In this case, a spouse failed to disclose a significant offshore bank account when signing the prenup. When the couple divorced, the court ruled that the prenup was void due to the lack of full disclosure, leading to a much more complicated and contentious division of assets. These examples highlight the importance of transparency, fairness, and timing when it comes to drafting a prenuptial agreement. A well-drafted prenup can provide peace of mind, but a poorly drafted one can lead to more problems than it solves. So, what should you do if you're considering a prenup? First and foremost, start the process early. Don't wait until the last minute. Give yourselves plenty of time to discuss your financial expectations and consult with your respective lawyers. Make sure you fully disclose all your assets and liabilities. This transparency is not only legally required, but also helps build trust between you and your partner. Remember, a prenup should be a conversation about protecting both parties, not just one. Ensure that both parties have independent legal representation. This not only protects your interests, but also makes the agreement more likely to be upheld in court. And finally, consider reviewing and updating your prenup every few years or whenever there's a significant change in your financial situation. Before we wrap up, let's take some questions from our listeners. We've received a few interesting ones on social media. First question: my partner and I are thinking about getting a prenup, but I'm worried it might set a negative tone for our marriage. What should we do? This is a common concern, but it's important to frame the discussion positively. A prenup isn't about planning for divorce. It's about ensuring that both parties are on the same page financially. Think of it as a tool for protecting your marriage by removing potential sources of conflict. Second question: can a prenup be updated after marriage? Yes, it can. In fact, it's advisable to revisit your prenup periodically to ensure it still reflects your current financial situation and goals. You can update it by drafting a postnuptial agreement, which functions similarly to a prenup but is signed after marriage. As we've discussed today, while prenuptial agreements can provide significant benefits, they also come with potential risks if not handled properly. It's crucial to approach the process with care, ensuring full disclosure, fairness, and independent legal advice for both parties. Remember, a prenup should be a tool that supports your marriage, not undermines it. If you're considering a prenuptial agreement or have questions about your rights and responsibilities under Ontario family law, don't hesitate to contact us at DivorceLawyers.ca. We're here to help guide you through the process with the expertise and compassion you deserve. Thanks for tuning in to this episode of the Divorce Lawyers podcast. If you found this episode helpful, be sure to subscribe, leave us a review, and share it with someone who might benefit from this information. Until next time, take care and remember, knowledge is power, especially when it comes to protecting your future.